We've read those written arguments. We've looked at authorities that have been cited to us by the parties, and where appropriate, looked at the record of the trial courts. So we will today be engaged in a discussion with the attorneys and try to reach a better understanding of those arguments as they present their oral arguments to us. You'll see that we have computers, papers, other things in front of us. We will often be looking at those, and I just want to assure everyone that we're still focused on the argument as we do so. We're looking at our own personal notes, at the briefs, at authorities or other things. Doing that helps us process and understand the arguments better. So bottom line, though, is to just assure you that we are still engaged in listening. I will now ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 a.m. docket.
Thank you. The first case on the 9 a.m. docket for Thursday, May 18th, 2023 is appeal number 125778, Regan Hodges as a representative heir at law and as administrator of the estate of Timothy Hunt versus Walinga USA Incorporated and Walinga Incorporated. Certified question from the United States District Court of Kansas. Briefs both sides.
May it please the court, Lyndon Vicks appearing on behalf of the plaintiff and representative heir Regan Hodges, ready for argument.
May it please the court, Randy Shear appearing on behalf of Walinga USA Inc., Walinga Inc., present and ready for argument.
Second case is appeal number 124724, State of Kansas versus Brandon Keith Jordan, Shawnee County. Briefs both sides.
May it please the court, James Ladd of the Appellate Defender's Office representing Brandon Jordan, ready for argument. And Madam Chief Justice, may I please reserve 3 minutes for rebuttal? Thank you.
Good morning. May it please the court. The state appears by Deputy District Attorney Jody Litvin, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. With that, I would ask the attorneys in 125778 to please come forward. That's Hodges as representative and heir at law and as administrator of the estate of Timothy Hunt versus Walinga USA and Walinga Inc. For you're settled, you may come forward to the lectern.
Thank you, Your Honor. May it please the court, Lyndon Vicks on behalf of the plaintiff Regan Hodges, who is the representative of the heirs at law of Timothy Hunt, who was their father. I would like to reserve 3 minutes, Your Honor, if I could.
3 minutes is granted.
Thank you. As the court is aware, we are here today on certified questions from Chief Judge Eric Melgren from the United States District Court of the District of Kansas. And there are 2 questions that have been certified to this court. These questions arise out of the one action rule. And as the court is well aware, that is a judge-made rule that is created and developed in case law, and it's designed to foster judicial economy. It arises out of our comparative fault system, and it provides that when there's been a judicial determination of comparative fault in one action, there cannot be a second action against different defendants that would raise the same comparative fault issues and potentially relitigate the percentages from the first action. But as this court stated in the Child's case, which is referenced in Judge Melgren's question, a plaintiff is not barred from bringing further suits against additional defendants concerning the same cause of action until it has actually received a comparison of fault at trial. And the court emphasized the words comparison of fault in that statement. The twist here is that the one action to which the defendants contend the plaintiff is limited is not a judicial action at all, but rather an arbitration proceeding. That proceeding occurred because of a contractual agreement between the plaintiff and the various entities collectively referred to as Butts Farms.
Could you back up here just a little bit? And I guess it might not even go to the questions of the certified questions, but you filed an action in federal court against Walinga only prior to entering into the arbitration agreement. What was the reason that the initial lawsuit didn't include Butts Farms?
Well, Your Honor, as I understand it, and I will admit, I was not involved in that aspect of it, but there was conversations already ongoing with Butts Farms, and this was in motion at the time that the federal court was filed. But
Arbitration was in motion.
the arbitration agreement was in motion. And so that was the way that aspect of the case was going at the time that the federal case was filed. So that was already on that path and ultimately came to the arbitration agreement, then the arbitration.
But the arbitration agreement was subsequent to filing of the case against Walinga.
I'd have to check the dates, but I think
the date.
I think you're right on
that
that.
out.
Yeah,
Okay.
yeah. So we have an arbitration, and the nature of an arbitration, of course, is it's a contractual agreement whereby the parties agree that they're going to settle their dispute outside of court proceedings, and they'll be bound by that arbitration decision. And the principle of freedom to contract allows the parties to define the scope of their arbitration proceeding. And the parties to the arbitration here agree that the arbitrator would decide whether Butts Farms had been negligent and what damages were sustained by plaintiffs. They did not ask the arbitrator to determine whether anyone else was at fault or to apply comparative fault principles, which would have to be done if it had gone through a court proceeding. They're free to do that. A court action requires the fault of all parties to be compared, and arbitration does not, because it's a contractual arrangement. So with that in mind, we can go to the questions posed by Judge Melgren. The first one being, under Kansas law, does an arbitration action qualify as a judicial determination of comparative fault where no other potential tortfeasors were involved in the arbitration? Now, the defendants have told you that they're not arguing that the arbitration is a judicial proceeding, so you don't have to worry about this one. I'm not really sure what to do with that. I don't know if a federal court poses questions to this court to answer, if a party can just say you don't have to worry about that one. So I am going to address it a bit here. The defendants say that you don't have to decide that because we're not taking the position that's a judicial proceeding, that the arbitration itself is not a judicial proceeding. We believe that an equally important point is that in an arbitration, or at least one here where comparative fault was not made an issue, it can't be a determination of comparative fault, judicial or otherwise, and therefore has no preclusive effect on a second action. The arbitration award here determined that the negligence of Butts Farms caused or contributed to cause the plaintiff's damages. That does not equate to a finding that Butts Farms was 100% at fault for the damages, as the defendants contend. A finding that Butts Farms was negligent and that negligence played a role in the accident was necessary for Butts Farms to have any liability in the arbitration, but it did not preclude the possibility that other parties were also responsible. There was no comparison of Butts Farms' negligence to that of Walinga or anyone else. And Walinga is not even mentioned in that arbitration award.
Well, it is mentioned at one point on page 624 of the arbitration award. And in fact, it states that Walinga mentions the model number of the grain vacuum system and says that it was defective and unreasonably dangerous in several respects. It seems to me that's just contrary to any finding of 100% fault of Butts Farms when it includes that language.
Well, that was done, Your Honor, in the context of the obligation of Butts Farms to provide a safe working environment. There is no evidence in the record of the way that this was manufactured. It was not made an issue as to whether there was a design defect, but the court found sufficiently that this was not a safe product that was provided to him. I think to find that that's a comparison of fault for the manufacturer, it would have to go quite a bit further than just referencing the piece of equipment.
But the duty that the arbitrator suggests is violated is the duty to provide to exercise reasonable care to provide safe equipment, right? So when that finding, I think that's in paragraph 24, and then the subsections explain sort of the defects in that system. That does seem to go one step beyond. How do you address that?
Well, I would say, Your Honor, that the arbitrator limited his examination of that to the duties of Butts Farms. He did not say, I find then that this piece of equipment being defective contributed separately from Butts Farms X percentage. That would be a fair finding of comparative fault. But as it is, I don't think that can be regarded as such a finding.
And there was no apportionment to the plaintiff either, was there?
No, because the arbitrator wasn't asked to make any finding of comparative fault.
I hate these certified questions because they come in a little box and sometimes you want to look outside the box, but there's some notion that if plaintiff goes to the jury in federal court action, jury would not be comparing fault against Butt Farms or even any unknown players that may be out there that would potentially have attributable fault to them.
Oh, I believe that their fault would be compared, Your Honor. I think at least if Walinga wanted to have it compared, I think KSA 6258A subsection C says that Walinga could do that. And it doesn't matter if the people that they want to have compared have been settled with, have had their
Even been sued.
or even been sued. Exactly. We talk about phantom defendants for comparison purposes all the time. All right. And so I would just say again that Butts Farms and plaintiff defined the scope of their arbitration so that comparative fault was not determined. And by definition, the one action rule cannot apply in that instance. But if we move to the second question, which to shorten it a bit is, if the arbitration award is not a judicial determination of comparative fault under Kansas law, is the fact that there was a confirmation of that award turn it into a judicial determination of comparative fault?
Before you start on that, my question, you led right into my question, which is just help me understand what practically happens for there to be a quote unquote confirmation of an arbitration award.
Under the Kansas statutes on confirmation, either party can file a motion after an arbitration. It's more likely going to be done by the plaintiff to ask for that to be confirmed. And that converts it into a judgment, which allows it to be more easily be enforced through collection methods. And
So
what have you.
is the confirmation essentially a court approval of a settlement agreement? That's my understanding of.
I believe it is, Your
The
Honor.
effect of that isn't to say, I put my judicial stamp of approval on all the findings. It's instead, let me put it this way. My understanding is, or my conceptual understanding is that an arbitration is effectively a fancy settlement agreement. And when it got under the statutes, when we talk about approval or confirmation, we're really just saying a court has approved a settlement agreement.
It has approved it and converted it to a judgment. I agree with that. And I believe that it's true that an arbitration is and fancy settlement is not a bad way to term it, because it's entered into and it comes to its fruition purely by contract settlement of the parties.
And my understanding is here we look to Missouri law for procedural aspects of this proceeding. And so do we look at, is that true also? I would assume since it was in a Missouri court, we would need to look to what their statutes might be on arbitration.
If I remember your argument, Your Honor, what the agreement said, it said that both Kansas procedural and substantive law would be applied, and to the extent that that wasn't filling a gap that Missouri law would at that point. But I think Kansas is the default law to go to.
So you think it would apply here?
I do. And that
And
is,
just in case we would disagree, do you know what the Missouri law is on this?
I do not, Your Honor. I would have probably relied upon the willing defendants to provide that, and they seem to agree that Kansas law applies to the confirmation. And so I agree that given the nature of this arbitration, we can look to Childs for guidance as to whether the court's approval of the settlement here constitutes a judicial determination of comparative fault. And in Childs, you had a settlement approved by the court because the plaintiff was a minor. And although the district court in that case found that the one action rule would apply based upon that earlier case, this court said, no, that is not a judicial determination of comparative fault. And I think that the same thing is true here, and perhaps even more so, because as we discussed in our brief, in a minor settlement approval process, the court has certain duties to make sure that this is a fair settlement to the minor and to involve itself quite extensively in that process. Whereas here, as Justice Stiegel suggested, really all the court does is make sure that the arbitration was on the up and up, that there wasn't some corruption or denial of due process along those lines, but there is no examination of the merits whatsoever in a confirmation proceeding. And once the court determines that all of that, that the procedure was conducted properly, we are directed by KSA 5-447A that the court shall enter a judgment in conformity with the award. And so the court confirming does not look beyond the award to determine whether the merits should have been decided differently.
Let me just ask you before you sit down, can you, and I know it's kind of a speculative question here, but can you envision a scenario where a arbitration confirmation by a state court judge in Kansas qualifies as a judicial determination of fault? Is there a scenario where that could happen?
I have thought about that, Your Honor. I've thought, for instance, what if these parties had gone to the arbitrator and said, we want you to compare the fault of all these people involved? I don't think so, because
Even in that scenario.
even in that scenario, because I still believe that that is, and again, I like the term, a fancy settlement. They have agreed that they're going to have their dispute determined in a non-judicial way. They could have done it by negotiation to come up with some number and even some assessment of fault. They could have had a mediation where that was done. Here they chose an arbitration, but it's not a court proceeding, so there's not a judicial determination of comparative fault within the mediation or the arbitration, and the mere approval of that by a court does not turn it into a judicial determination.
Thank you.
I see my time's up. I think that's all I have till rebuttal.
Here.
May it please the court. Randy Shear appearing for Walinga Inc. and Walinga USA Inc. Let me start with Justice Rosen's.
Yeah, please do.
question.
Go ahead. Good.
Because I think that's the reason why we're here. And I think that's why we moved in our brief to the second certified question, not to disrespect Judge Melgren or to say he was somehow wrong, but the first question is really more of a hypothetical. Can an arbitration action qualify as a judicial determination of fault? Maybe, it depends. And so it depends on the facts and the circumstances, and those facts and circumstances and the record, the uncontroverted record that was before the court in the federal district court, and the uncontroverted record that's before the court here provides that context. And that context is very important because clearly, although this court and the appellate courts in Kansas have not addressed this issue before, there clearly is, under the framework of Kansas law and even precedent from this court, where an arbitration action that actually is an adjudication of the merits of a party's claim of negligence against a party for the wrongful death and personal injury of a decedent, that results in a finding of negligence and fault on the part of a defendant, one but not all potential tortfeasors, as it happened here in this case, that where the party submitted their entire claim. It was after a full evidentiary hearing, applying Kansas substantive law, and there were specific findings of fact and conclusions of law, finding the bus farm defendants negligent and at fault, and assessing their total damages in the amount of $12,250,000. And it didn't stop there. It went further than that. It went to a judgment and was confirmed. And by specific request of the plaintiff's counsel, they asked the court to specifically incorporate by reference those findings of fact and conclusions of law, which then became a judgment, which is a final determination of the rights and of the parties in that action. Under that circumstance, that is where you can have a judicial determination of comparative fault out of an arbitration action.
Help me where in the arbitration award there's any comparison of fault with your client. I don't see that. I know we look at the only mention is that paragraph 24, but that seems to imply that wasn't done and that your client has an inherently dangerous product out there.
And Justice, I'm glad you asked that question because that's an important issue that I wanted to address. It was addressed by Judge Melgren in his memorandum and order, and we addressed it in our brief. The reason why there was a comparison of fault is because there was a finding of fault on behalf of the Butts Farm defendants. Totally. There was no finding of fault against the decedent, which could have been found by the arbitration award and incorporated in the subsequent judgment. But there was a finding of fault against the Butts Farm defendants. And that is comparable to what this court found in Mick versus Manning, where there was no comparison of fault at all. In fact, there was a defense verdict. And by design, similar to what happened here, Dr. Manny wasn't included in that action, so his fault wasn't compared. In fact, there was no comparison of fault. And this court specifically said that even though there was no comparison of fault against any other potential tortfeasors, in fact, none, this court said, and I quote, "This was a determination of comparative fault." And that's on page 93 of the Mick versus Manny case. So you don't have to have a comparison of all fault, especially where, as here and is in Mick versus Manny, the plaintiff makes a purposeful election and by design excludes all potential tortfeasors and only proceeds to ask for an adjudication of the determination of fault against one, but not all tortfeasors.
The fundamental process is very different though for arbitration versus the court proceeding. In the court proceeding, you have rules about joinder and jurisdiction and a number of other factors that can lead to the ability to bring all the parties together. Arbitration, not necessarily. It's a matter of contract. And that contract may be pre-existing the injury in some cases. So that you don't even know who else might be a part of that. So does that give us a fundamental reason to not put arbitration in the same basket as we do something like the Mick case?
I would agree with you to some degree, Justice Lugar, that it is not exactly the same, but is one of the many processes that is allowed and sanctioned under Kansas law to provide for the adjudication of a party's claims on the merits. We know for a fact that under the Kansas framework, a party has a right to a trial by jury, but that can be waived, which it is in some circumstances. And it certainly was waived in this case voluntarily and purposefully. It can be waived and then the case could be tried and adjudicated on the merits to the judge, the trial judge, or under 60-253, it could be tried by a master, which is very similar to the process that's allowed under and recognized under arbitration. That's 60-253. And in fact, the parties can agree under a trial by master for findings of conclusions of law and findings of fact that are to be adopted by the trial court in a judgment absent clear or clear error or clearly being erroneous. That's under 60-253.
Let me ask a question. If we don't know, I don't think these facts are in the record, but if you say that there was a contractual agreement to arbitrate, whether it was pre-injury or not, between Hodges and Butts Farm, et cetera, and then Hodges comes to Walinga and they say, we're not going to arbitrate. There's no mandatory way to bring in Walinga, right?
That's true, but let me expand on that a little bit if I could, Justice Sanders. We were never given that opportunity, but that's also, you shouldn't disregard or set aside the fact that the plaintiff actually made that choice. They made that purposeful choice in election to bring a separate action, and whether it was through arbitration or through a separate lawsuit, as we have seen happen in Mick versus Manny, for example, that was a purposeful election and design and strategic reasons that the plaintiff will have to explain to you. They made that election. But it
But
makes it,
Walinga obviously was on notice of the accident, right? Because, I mean, there was a federal court case.
we were on notice of the accident, but we didn't know about this arbitration. In fact, I will tell you that there was some degree of secrecy because we didn't find out until after the judgment was awarded. We didn't even know that they were doing this. We didn't know that this had happened. So we weren't given that opportunity, but they still made a purposeful election, a decision not to do that. And I should point out that they had the option to bring the Butts Farm defendants in our action. They certainly could have done that. Butts Farms is located in Wichita.
Isn't it our public policy that the plaintiffs get to decide how they want to pursue their claims?
They could, but there are consequences. And the
How-
consequences are the one action rule.
I'm sorry, I didn't mean to interrupt you. Then how do you explain the holding in Childs then, where this sort of notion that once you make your election, you have to live by this one action rule? With Childs, there's two, separate lawsuits. One party settles, but there's not an adjudication of fault. So how does your argument survive the rationale of Childs?
I think that you touch upon the important distinction, and that is that Childs actually involved a settlement. There was no adjudication on the merits of the actual claim. There was no determination of fault as there was here. And I think that is the clear distinction. And I guess the other thing that I wanted to address, and I think it goes to Justice Siegel's comment about whether this is actually a fancy settlement, and that's to suggest that arbitration is something less, or something that should be regarded as something less than an alternative action by which there can be an adjudication or determination of someone's fault. I think that's contrary to the Kansas Uniform Arbitration Act. I think the Arbitration Act clearly provides that is a viable way through which a party could present its claims for an adjudication of fault. I think we should make no mistake that there was an adjudication of the plaintiff's claims fully. Evidence was submitted. There are provisions under the Kansas Uniform Arbitration Act for a fair and impartial proceeding.
No, go ahead.
What would have happened had the arbitrator actually made a finding that your clients were at fault by, I don't know, 50% at fault?
Probably wouldn't have had any effect because we wouldn't, but there was certainly
Would you turn around and pay it?
No.
Well, right,
I-
of course
I-
not. So my follow-up question is, how does making your client defend itself in this lawsuit work any kind of unfairness or injustice on you, on your client?
Well, to address that, Judge, I don't think there's the requirement of showing a prejudice, but let me.
Well, these are policy-based rules, and I'm interested in the policy at least for purposes of my question.
I understand.
And I'm trying to figure out how this works in injustice on your client.
And for purposes of the policy, the plaintiff has had its day in court, or it's had its adjudication of the claim, and there has been already.
I'm sorry to interrupt, but that would make sense to me if you were to say, yeah, if we got found at fault in the arbitration, yeah, we would pay it. Like, that would make sense to me, this whole idea of you get one shot and that's it. But the reality is, I just don't think that your client in your situation would be happy with an award that found them at fault in the arbitration agreement or in the
Judge,
arbitration.
I think that would be a situation in any case, let's say this had been filed in the district court, but Walinga had not been named, but they proceeded to go ahead and ask the jury to assess fault against phantom defendants or defendants who were not physically present. They could have done that, but it would have been the only party that would have been binding on was were the defendants who were the Butts Farm defendants in this case. So I think there are also issues of res judicata. I don't think there's any question that res judicata applies here with respect to the previous findings and this judgment that constitutes a final
Let
determination.
me ask you a question about that. Can you ever envision a scenario where a judge would not confirm an arbitration award?
Yes.
And in what circumstances does that happen?
If the arbitrator exceeded his authority, or there were irregularities in the process to show impartiality or unfairness. But and these are listed under the Kansas Arbitration Act as basis for to vacate. So there are certainly circumstances under which that's happened. I understand that the review standard is much tougher, but there is still a review standard nonetheless. And it still constitutes an adjudication of the claim on its merits, which exactly happened. One case that I do want to
But you're
refer
not
to.
suggesting that this arbitration confirmation was tainted by some sort of defects, are you?
I don't know, because there was no challenge to that. I just know that per the representation of the plaintiffs when they made their application, that they represented that it was their claim was submitted in full. It was adjudicated in full on the merits, that they had a full evidentiary
So
hearing.
that means the judge doesn't undertake sua sponte a determination about whether they misapplied the law or whether it was tainted by defects or biased. So how can it be anything more than a rubber stamp?
The judge could do that. Judge, I understand what you're saying. And he takes the representations of the party pretty much on its face, as a lot of judges do in a lot of different circumstances. But
What does the statute say about that? That the judge has to independently, regardless of what the judge, kind of like a minor settlement, which of course, doesn't help you in Child's, but in a minor settlement, there is a duty of the court to independently review to determine whether it's fair, just, due process concerns. Is that similar in the statute here?
that can be within the discretion of the court's review. Under
Right,
the
but what does the statute say?
That's
Is it
one of,
mandatory?
that's one of the elements on which the judge could. I don't think it's mandatory, but I think it's one of the elements under which a judge could.
But under a minor
Review.
settlement, the judge has to.
That's true. That's true.
Could Butts
but-
Farms, I'm sorry,
Go ahead. I'm sorry.
could Butts Farms have contractually forced the arbitration?
I don't think so. It was by agreement. It was by purposeful election and design. And let me just say one other thing, because I think it goes to the suggestion that an arbitration is something less, that it can result in something less than an adjudication on the merits that can result in a determination of comparative fault. And I'll cite a case that I came across after I looked at the reply of the plaintiff's reply in this case, and Judge Dandridge, it has to do with a case that you were involved with when you were on the Court of Appeals. It's Diedrich versus Yarnovich, 40 Can App Second 801, 40 Can App Second 801. And in that case, it talks about our prior arbitration, where in the context of the one action rule, in the context of a party trying to split his causes of action. And this plaintiff filed an arbitration asserting his contract claim, and then he lost, and then he subsequently filed a district court action where he pursued a tort claim. And the Court of Appeals says, no, for purposes of the one action rule in the context of splitting a cause of action, that prior arbitration constituted a prior action, an adjudication on the merits. And you're one bite at the apple, you're done and over.
Was that, but of course, you're asking me to go way
I
back.
figured you may be familiar with that, Judge.
Right, well,
Yes, yes.
I'm not sure I remember the facts exactly, but didn't that have to do with whether or not the cause of action was sounded in tort or contract? Wasn't that the main issue?
It was a splitting of a cause of action. It was from the same conduct, and he claimed, and he
Right,
claimed.
well, we don't have those facts here, do we?
It's different, but it's still the point. I understand that there's a difference, but the teaching point, I think, of that case is that for purposes of applying the one action rule, for purposes of splitting a cause of action, this court clearly recognized that a prior arbitration was that plaintiff's bite at the apple. There was adjudication on the merits.
Right, but
Got it.
but then what they did was they went and tried to do the same cause of well, I guess it wouldn't be the same cause of action, but based on the same facts, made it sound in tort.
Tort,
or
that's right.
Right. And so
But-
that's a big difference.
It is a difference, but it's, but the point that I think that's important here is that it recognizes that an arbitration constitutes a prior action for purposes of a one action rule. And I think that similar
Against
principle
the same
applies here.
defendants.
Right, but in terms of the claim
But it was
here
against-
was a determination of the fault, whether it be the bus foreign defendants or the Walinga defendants. And the one action rule in Kansas regarding that clearly says you should do that in one action.
Is your argument that the one action rule prevents your client from being liable at all? Or is it that the plaintiff is restricted by the first action in the second action?
Well, depends on what happens here, probably, but
I know, but I'm trying to understand so again, back to my hypothetical, if an arbitration award had explicitly said, your client is at fault X percentage, you're not saying that you are free from any liability. Are you?
I think under the application of the one action rule, if you don't bring that all the parties and have that determined in one action, then you don't get a second bite at the apple.
So you are saying that just the mere fact that your clients were not included in the arbitration means King's X, they cannot be held liable, period.
I don't think it's because of the fact that we weren't included. I think it's because of the fact that there was a adjudication on the merits and a determination of fault of one, but not all the tort.
Okay, but that goes,
That's-
okay, so change the facts a little bit and assume with me that your client was expressly found to be liable by the arbitrator.
Yes,
You weren't there, but that finding was made.
right.
I don't think anyone thinks that you would be bound by that.
That's true.
But are you saying that even that finding means that you're not liable at all in a
I think
second
so.
action?
And I think that would.
How does that, that's what I'm having.
That would
trouble.
be even clearer evidence that there was not only a determination of fault of the Butts Farm defendants, but of all the tort fees,
that how
even
the-
though they weren't joined.
Is that how the one action rule works?
I believe so.
To
Yes.
preclude any liability, or is it to just say, we're not going to relitigate the comparison of fault? Does that distinction, am I articulating my question?
No, you are, Justice, and I understand, but I think as I understand the one action rule in Kansas with respect to comparison of fault, if that doesn't happen at the time when the original negligence is determined, and in this case, it would have been when they got the judgment against the Butts Farm defendants, then the case is over. That's consistent with this court's opinion in Albertson as well as McPherson.
If that's the rule, does that create a strong disincentive to arbitration? And wouldn't that be against the public policy of our state that favors arbitration?
No, because especially in this case, it was a purposeful election and design to do that. They purposefully waived their right to a jury trial and they purposefully elected to go this route, just as
Well,
other
if
plaintiffs
they
have.
lose this case, future clients in the same situation are not going to make that election.
Well, maybe not, but in this case, they seem to have landed on their feet because they got an award of $12.25 million and have an enforceable and binding judgment that's binding on the plaintiff and the Butts Farm defendants. And so they have that.
It just seems to me that the rule you're asking for would give entities like your client essentially an absolute veto over the possibility of arbitration with other co-defendants.
Not necessarily, that's probably a case by case basis, but I guess I would flip that and judge and ask the court to consider what would happen if we do carve out an exception under this circumstance. And I would suggest that it would create a loophole that would effectively eviscerate the one action rule by giving the plaintiff's attorneys an option to circumvent it by cherry picking one or more tortfeasors who may be willing to go an arbitration route to get multiple bites at the apple. And it's not, I think it would invite mischief and some confusion and create a loophole that should not exist.
Found that to be true. I mean, back in the day, I was in lots of cases where there were multiple defendants going into just a settlement conference. And, I would sit there and say that one defendant was being unreasonable by sitting on their hands and others were being too generous by getting out their checkbooks. And it, end of the day, I still got to go to trial or I got to settle depending on what was in the best interest of my client, what my client wanted to do. I just don't see the list of horribles here.
Well, Justice, and I guess in the context of settlement and mediations, I think that your point's well taken, but the binding arbitration is something a bit different. I mean, it is a commitment to submit, not unlike submitting to a trial by a master under 60-253, those claims for adjudication on the merits for a final determination that will eventually end up in a judgment, good or bad. I mean, it could happen both ways. So it's a purposeful election to waive your right to a jury trial, but it's an alternative way to get your case adjudicated on the merits.
But only as to that one client. I mean, here's my follow-up on that. Let's assume Butts Farms turns around and sues your client for all the money they have to pay in this arbitration agreement. You're not bound by, I assume you would argue that you're not bound by that amount as being the damages of Butts Farms for having sold them a defective product. You're going to say the arbitrator was too generous and they didn't defend themselves as well as they should have or whatever. But you're going to argue that dollar amount, it might even be all the way down to zero, right?
Well, just
You're not bound. I mean, so that number doesn't mean anything to you in, an action by Butts Farm against your client.
I think you're correct. I'd agree with that, but I don't think they'd be allowed to do that because there's already been an adjudication. And I think res judicata against them by virtue of the arbitration award and the judgment, which is a final determination of their rights and liabilities, where the judgment basically says that they are liable for $12.25 million. It's not for a part of it. It's not for a percentage of it. They're on the hook for that's theirs.
So that arbitration agreement gives you an additional defense in any claim that your buyer might bring against you for having sold this equipment.
And Justice, I would say that I would go farther than that. I think it's more final than that. I think pursuant to Albertson and Manny, Dick versus Manny, the case is over. They had their shot to determine fault. They elected not to join all the parties in a single action, but to go this route. And under Manny and Albertson, the case is over. Any other questions? Thank you, Justice, for your time.
Make notes when you're sitting there and you come up here and it's just gibberish. I'll try and hit a couple things that crossed my mind. Hadn't heard about the Arnovich case in the context of this before. I'm a little familiar with that, having cited it on the you don't get a contract action and a tort action for the same conduct. I think if it was an important case here, we would have seen it in the briefing or at least in a Rule 6.03 letter. I think the key in that case was that the plaintiff was trying to sue the same defendant after arbitrating with them. I think that's quite a bit different. I agree that plaintiffs get one shot. They get one shot at a court action. And my clients have not had one shot at a court action. They went to an arbitration, and that is not the same as a court action. If, as the defendants contend, your choice of an arbitration cuts off any subsequent attempt to sue in court against other defendants, the same could be said of a negotiated settlement with one defendant. The same could be said of a mediated settlement with another defendant. This is an arbitrated settlement with one defendant. It should cut off nothing as to other defendants. I think the Child's case made this kind of explicitly clear when it said each plaintiff must be allowed a trial judicially determining comparative fault, regardless of whether the plaintiff had the opportunity to do so earlier in one action. My client hasn't had its trial to determine comparative fault, and it's entitled to that. And the defendant talks about this horrible thing about cherry picking this defendant and this defendant and this defendant. I think it be back, even though they say prejudice is not an issue here. It is an issue, and this court recognized that in the Mathis case, where it pointed out that TG&Y is not prejudiced by allowing the suit to proceed. It may join other defendants for the purposes of comparing negligence at trial. They can do that too. They're not going to pay more than their fair share as determined by a trier of fact. That's going to determine the amount of damages. And it's going to determine their percentage of fault. On the other side, if they can get out because there was an arbitration ahead of their case, they'll never be held to account for the conduct that they're accused of. And I would suggest, Your Honors, that that is not the interest of justice and should not be allowed. Thank you.
Thank you to both parties for your arguments today. The court will take this under advisement. I will now call 124-724, State of Kansas versus Brandon Keith Jordan.
May it please the court, James Latta of the Appellate Defender's Office, representing Brandon Jordan. We're here today on a felony murder charge with the inherently dangerous felony being a fleeing and eluding, which ended in a deadly car crash. And to jump straight into issue one, the first issue is alternative means. And I would like to start by saying that we're here on an alternative means issue because the state chose to charge this case with numerous and/ors in its charging document, listing out multiple alternatives of how the defendant could commit a fleeing and eluding. Then at trial, the state requested numerous and/ors in the instruction, including alternative means for fleeing and eluding. And after the state requested that, the district judge even said, I think sometimes it's too confusing to have all those choices. And we went ahead with it. So that's why we're here now with this issue. And as this court has said in Davis, subsections B1 and B2 are, we already know, are alternative means. When you insert those alternative means into felony murder, we now have alternative means for felony murder. And as we go through all the and/ors, we come to the possibility that the jury could have convicted of fleeing and eluding for the and/or of identity theft. And then when we turn to the identity theft instruction, we find that once that identity theft instruction is inserted into fleeing and eluding, there is a component of that of the identity theft instruction that as a matter of law could not have occurred while fleeing and eluding. And that's Brandon Jordan lying to the police officers about who he was. That had happened after the crash when he was no longer driving a motor vehicle and he was no longer committing a fleeing and eluding.
I understand your argument. What we have to decide to get to your final conclusion is that under B2, listing more than one felony for which a defendant was attempting to elude capture creates an alternative means issue, not options within a means.
That's correct. And so my best case for that is the Sasser case, which I cited in my reply brief, which specifically says that alternative means isn't just about insufficient evidence, it's about jury unanimity. And it goes on to talk about how the instructions can cause all these issues with alternative means. So once I raise the issue of alternative means, we have to, in my opinion, based on the case law, that's the world we have to live in. So now when we look to B2, which is the alternative means of attempting to elude capture for forgery and/or identity theft, in order to be sure that that entire alternative means is sufficient, that there's sufficient evidence to support forgery and/or identity theft, we have to show the whole thing. It's not sufficient just to show that the forgery was sufficient, because based on the instructions and based on the Sasser case, we can't know that for sure.
Start though, in alternative means by looking at what are the material elements of the crime. And the fleeing and eluding statute itself only says commission of a felony. It then references you to a definitional, basically list of what those felonies can be. And then that in turn shoots you to another statute to define what those or a multitude of statutes to tell you what the elements of those are. And in Brown, we said basically anything that is a definition or a description is an option within a means, not an alternative means. So what's your argument as to why we wouldn't apply that holding from Brown here? When you don't have that, those secondhand cousin, the second cousin elements in the fleeing and eluding statute itself.
Sure. And just so I understand your question, are we talking about subsection B2 about the forgery and identity theft? Why those aren't just options and a means?
Right, right.
Sure. And my best argument for that is that we are now in the world of alternative means, like I said. We do
Right,
not,
so maybe we would start and breaking this down. There's nothing in that subsection that refers to those elements, is there?
to forgery and identity theft?
Right,
No, it just says any felony. You're
it
right.
says any felony. So why isn't that almost a hard stop to say that is not an element of the crime of fleeing and eluding? You just have to commit a felony. That's the element of fleeing and eluding. And then the legislature has defined what felonies qualify, but that's a description does that fall within the description holdings of Brown, where we say no, anything that's a description of a element is an an option within a means.
So basically you want me to tell you why? Because the state proved forgery, that's not sufficient. Is that correct?
No, I want to say why under Brown, this is not to get over to a felony, the specific felony. Why that is not a description as opposed to an element of fleeing and eluding.
I understand. And my answer would be, it might be a description. And the reason why that doesn't matter in this case is the Sasser case, which says that the jury instructions themselves can insert the lack of unanimity that we're worried about.
We're not worried about lack of unanimity if it's options within a means. That's the whole point, isn't it? Is that if it's options within a means, we're not worried about unanimity.
I agree. And I would go back to saying that we are in the world of alternative means. And the only way we can know for sure that the entire alternative means of B2, which is forgery and or identity theft, is for the state to have proven both. There has to be substantial evidence to prove both.
That answer is contrary to your answer to my question, that we're talking about a description or a definition, because under Brown, that's an option within a means, not an alternative means.
Right. And my best argument on that is just that it doesn't matter because of the way the instructions are worded. And again, the Sasser case is my best argument on that the instructions can.
Would you agree that this jury was unanimous in its finding that that your client made a felony? I mean, it was, right? It was unanimous on that question. It might not have been unanimous on the question of which felony, but it was unanimous on the question that your client committed a felony.
Because we have separate verdict forms, knowing that so we know for sure that they found he committed a felony.
No,
they're
because the
separate.
instructions charged with forgery, they were instructed on forgery and they convicted on forgery, for example. Or they were instructed on identity theft and convicted on identity theft. I
Right.
think. Sorry, I didn't mean to interrupt.
Or just because they found that the fleeing and eluding happened. That's the element of fleeing and eluding, and they found the defendant guilty.
Right, but they could have found him guilty under their subsection B1 because of all the and ors. And so that wouldn't prove the alternative means of subsection B2. And
You
so
don't dispute that there was sufficient evidence of B1.
I do not dispute that. And I also do not dispute that there was sufficient evidence of forgery. We are trying to burrow all the way through and try to get to that identity theft and trying to say that the entire alternative means of B2, because of the jury instructions in the Sasser case, they have to show that substantial competent evidence supports each one. And because of the instructions, my argument is that forgery and identity theft makes up the entire alternative means.
Should we look at this as an instructional error issue rather than alternative means? Is that the better lens, since it seems that you're suggesting that all of this arises based on the way the jury was particularly instructed here.
Sure, and there is an instructional error too. There's probably a instructional error with factual appropriateness. But it wasn't objected to, and then I'd be under the clear error standard. So that's why I purposely raised this issue under alternative means. And because that's our best chance at getting reversal of the charges we need reversed for my client.
Claim that there's any evidence at all that would support the theft alternative mean that you're talking.
So there is
One
evidence.
that you say that there's no, that you're saying there's no evidence to support one path. And
Correct.
so now we're back in that fun discussion we always have about harmless error and all that. Because there's no evidence to support it.
Right, and so I would just say that, so that's why this is why I'm raising this as an alternative means issue. To try to get away from harmless error. Because if we get to harmless error, then I can't concede it, but I certainly admit we have a hard road ahead of us. I would note though that in closing, the state did say to the jury, they said, ladies and gentlemen, the state has presented either each or elements. So if you find one, that's enough. So that's at volume 13, page 634, 635. So the state did tell the jury that they could pick just one of those and/ors. They didn't say they had to agree on all of them, and they didn't elect just one for them to agree on. Then if there's no questions for issue 1, I'll move on to issue 2 quickly. Issue 2 is that the state, Shawnee County in particular, is not bringing these indictments in the correct way. Is that the way the statutes are written is an indictment can only be used to start a prosecution. And so there's no law authorizing these indictments to be substituted in the middle. And we cite the statutes that talk about bringing the indictment in the first place. And they talk about, it says a prosecution shall be deemed to have begun. Well, that's not what happened here. They filed the indictment in the middle after it had already begun by complaint. And my argument is that because we get jurisdiction from the statutes of Kansas, and the statutes specifically tell us how to bring cases in Kansas, when you don't bring a case the right way, there is no jurisdiction for that court to hear that case. I'd also direct this court to the statute that's cited in the indictments, that the statute 22-2303, which says when an indictment is returned as provided by 22-3011. When you go to 22-3011, subsection C, it says indictments found by the grand jury shall be presented by its presiding juror in the jury's presence to the court and shall be filed and remain records of the court. So my reading of that subsection is, because the state talks about in its brief that we just dismiss this and then bring in the indictment, and rather than doing the substitution thing. And they could probably do that, but they would have to dismiss the complaint based on my reading of these statutes before they even convene the grand jury. Because when you combine these two statutes together, I think the most plain reading is once that grand jury returns an indictment, you have to file that indictment, and you have to file that in a new case, because it says an indictment, a prosecution shall be deemed to have begun once that indictment is filed. So that's my argument on that. And if there's no questions, I would just ask this court to reverse based on my briefs, please. Thank you. Thank you.
Good morning. May it please the court. Again, my name is Jody Litvin, and I'm a deputy district attorney who represents the state in this matter. I think this court has generally hit on the points that I wanted to make as far as issue 1, looking at jury unanimity as the problem or the complaint here for the alternative means. We have separate jury verdicts for the forgery and the reckless driving and the identity theft. So I don't think the jury unanimity issue is a problem here, and that this court can have confidence that the jury did unanimously find him guilty of
By
forgery.
making that argument, are you conceding that the statute presents alternative means?
You know, I don't think I thought about that in the brief. But I don't want to concede that, no, but I don't know that I made the argument that it's not, but I do agree that under Brown, I think it can be any felony is the means. And as far, I didn't have any other comments. I mean, unless this court has questions on that issue.
Well, if it is alternative means, there were multiple acts that were identified in the instructions for identity theft, right?
Correct.
Okay,
There
and
were multiple intents to
Well-
defraud multiple.
correct.
Yeah.
Yes. And one of those could not, I don't know if you say as a matter of law or fact, but could not support a fleeing and eluding under B2. Would you agree with that?
I don't think,
Because that identity theft happened after the fleeing and eluding crime was completed.
correct. I don't think that was occurring. Yeah. I mean, he gave the fake name to law enforcement after the crash.
So does that not create a unanimity issue if multiple felonies identifying multiple felonies under B2 creates an alternative means issue?
I mean, it creates a jury unanimity issue, but I think you can find that harmless because we have other jury verdicts that say that the jury unanimously found on forgery and on other felonies. So like.
But that's
as
not
we-
the case. I mean, we don't know that. I think what Justice Wells is driving at is we don't know that the identity theft conviction was used by the jury to support the fleeing and eluding.
The way that the fleeing and eluding instruction was written, yeah, it didn't specifically parse out each one, correct? But if we have another felony that they unanimously found a legally adequate felony, adequate theory, then what's the harm in knowing that the jury did unanimously find him guilty of a felony? I mean, I guess that just goes to my harmlessness as to why this should be more of an instructional issue, not a sufficiency issue where it's bam, gets reversed. There wasn't sufficient evidence for that. We have to start over when we do have a jury verdict that says we did find him guilty unanimously of this felony. So I think it should be treated more like an instructional error. And as far as the second issue, the state, as we argued in the brief, says that there's no problem here in the way that the state substituted the indictment for the complaint. I think it's a matter of judicial economy. I don't think a grand jury is, we don't do that every week or every day. So we file the complaint first, and then when the grand jury is convened, they issue their indictments and we file them. I don't think there's any prejudice to the defendant here, and I certainly don't think there was a lack of subject matter jurisdiction for the court in the way that this was done.
Why isn't there some prejudice to the defendant to do it this way? Maybe not legal prejudice, but just the fact that you have to sit under the shadow. I mean, you have to be, a case has to be initiated against you under the complaint procedure, but then you lose your preliminary hearing opportunity. And is that why the state is doing this?
To lose a preliminary
Well,
hearing?
in other words, you're filing a case with a complaint. And then sometime after that, you are presenting the evidence to the grand jury to get an
Right.
indictment.
Right.
Why is that happening?
I mean, well, one, I think there's a charging deadline for when if you were arrested, and there's a charging deadline to have to get charges on file. I think practically speaking, there's a timeline for when the state has to file charges after an initial arrest. So we filed a complaint because the grand jury, like I said, isn't convened daily. And then when the grand jury is in session and they file their indictment and they find what they find, the state proceeds on that. And it's just giving notice of the charges twice, essentially. So I guess I don't see the prejudice.
Well,
And-
there are real practical implications and effects of being charged with a crime.
Yes,
So it's not just notice.
no, I mean, it's not, but it's allowed under our grand jury statutes. I mean, I don't know that it does take the place of a preliminary hearing, which is authorized by the grand jury. Defense may not like it, may not like to be, that they don't get that process, but there's nothing, it's set out by statute as something the state can do.
Yes, I agree with that. Is there any sort of bigger principle of justice or equity that would suggest that the state ought to be held to its initial election of how to proceed with the case?
I don't know that I don't know that the states has to be, there's anything in the statute that says that we're bound by the way that we initially do that. Because it says complaint, indictment, or information. So I guess my answer would be no. And I don't think I have any other presentation. I could hit on the prosecutorial error since I have time. Our position is that the state did not properly comment that this witness told the truth. If you look at in context, and if you look at the case law, this is certainly something that this court has said prosecutors are allowed to do when we have two conflicting sort of stories or testimony. And here that's exactly what we had. We had the witness saying that the defendant told her that he wasn't going to stop consistently to law enforcement, and that he said that he didn't see the trooper behind him until right before the stop. And so the prosecutor here was just asking the jury to consider the motive in the witness testifying consistently to law enforcement that he didn't see, or that he said he wasn't going to stop, and find that credible, and find the defendant's testimony that he did not see the trooper until right before the accident not credible. So if this court has no.
But did she go too far when she kind of asked the rhetorical question, what motive is there to, misrepresent here? And then goes one step further and answers that rhetorical question, says that I submit that there's no reason. Does that sound more like personal opinion?
And the state's view, no, because it was embedded in what the evidence was. So she was talking about her consistent testimony to the different law enforcement officers. So I think when you couch it within what motive does this witness has to tell, trooper so-and-so this and lieutenant so-and-so this way after the fact, look at this consistent testimony and find that credible. So, and I wouldn't say that it's like the cases where the prosecutor or the state has specifically said, she's telling the truth. Look, this witness is telling the truth, and some of those other blatant cases where this court has found error. I don't believe I have any further presentation for the court.
Questions? Thank you, counsel.
Unless this court has any questions, I'd waive rebuttal.
Thank you,
Thank
Mr.
you.
Levin. Thank you to both counsel for your arguments. We will take this matter under advisement. Court is now in recess until 10:30.